Hey y'all, these are some documents that were released yesterday. There's 6 in total. This video is going to have 3. This first document is a motion to declare section 921.141 and or section 921.1416D Florida statutes and or corresponding 6D jury instructions unconstitutional, and it quotes felony murder. It states, the defendant, Stephen Michael Stearns, by and through his undersigned attorneys, moved this court for an order declaring statute 921.1416D Florida statute unconstitutional based on violations of the 5th and 8th and 14th Amendment to the United States Constitution and Article 1, Section 9 and 17 of the Florida Constitution based on the following. 1. Mr. Stearns is charged with committing first-degree murder. The state has filed notice of its intent to seek the death penalty if there is a conviction on the capital charge. In the state's notice, it has announced its intention to rely upon the aggravating factor contained in section 921.1416D. And it cites this specifically. The capital felony was committed while the defendant was engaged or was an accomplice in the commission of or an attempt to commit or flight after committing or attempting to commit any robbery, sexual battery, aggravated child abuse, abuse of an elderly or disabled adult resulting in great bodily harm, permanent disability or permanent disfigurement, arson, burglary, kidnapping, aircraft piracy, or unlawful throwing, placing, or discharging of a destructive device or bomb. Number 2, the statutory aggravating circumstances is unconstitutional as written under the Constitution of Florida and the United States Constitution because the least culpable form of first-degree murder can be used as the sole basis to impose capital punishment in Florida in violation of the prohibition against cruel and unusual punishment, as written and applied in Statute 921.1416D. Florida statute violates Article 1, Section 9 and 17 of the Florida Constitution as set forth in the memorandum of law that accompanies this motion. While I'm scrolling through this, just by the way, we talked about these documents in my live from today. If you would like to see that, it has a picture of Madeline with what looks like kind of a mermaid background, and it's a picture of her in a little tutu, and it's titled New Documents We Need to Discuss ASAP. Continuing on with the document, number 3, evolving standards of decency prohibit execution for felony murder. The felony murder aggravator does not narrow the class of death-eligible offenders to the most deserving. In Florida, the only matters that may be considered an aggravation are those set out in the death penalty statute. They cite Zach versus State, emphasis added section 921.1416 of Florida Statute 2005. Aggravating circumstances shall be limited to the following. In Florida, the aggravating factors set forth in Statute 921.146 Florida Statute actually define the crimes for which capital punishment may be imposed. The State versus Dixon is what they cite. The existence of one or more aggravating factors make a defendant eligible for the death penalty. They cite Elm versus State. A defendant is not eligible for the death penalty if there are no statutory aggravating factors because the Florida death penalty statutory scheme expressly requires that sufficient aggravating factors exist before a defendant is eligible for imposition of a capital punishment. Statute 921.1412B 2A Florida statute, emphasis added. Each statutory aggravating factor upon which the imposition of capital punishment rests is a component of whether a defendant is eligible for capital punishment in Florida. A jury could find that one or more statutory factors are not sufficient to justify imposition of capital punishment by the judge. A defendant is entitled to a unanimous jury determination beyond reasonable doubt as to whether sufficient aggravating factors exist that legally and factually authorize capital punishment. It is well established that the 8th Amendment requires that a capital sentencing scheme must genuinely narrow the class of person eligible for the death penalty and must reasonably justify the imposition of a more severe sentence on the defendant compared to others found guilty of murder. They cite Lowenfield versus Phelps, quoting Zant versus Stevens, where the eligibility for the death penalty depends on finding, quote, sufficient aggravating factors. The felony murder circumstance becomes an automatic aggravating factor following a conviction of first-degree murder and does not serve the constitutionally mandated purpose of genuinely narrowing the class of persons eligible for capital punishment. In Lowenfield, the court approved a death sentence for a felony murder conviction, where Louisiana provided for the necessary narrowing in its definition of murder. In Louisiana, a murder conviction that subjected one to the death penalty required a specific intent to kill. It says LAREVSTATANN statute 1431 West 1986. In Florida, the felony murder factor simply repeats the offense of felony murder. Does not require any additional intent, and therefore does not genuinely narrow the class of offenders who are eligible for the death penalty. The egregious and unconstitutional nature of this aggravating factor means that a person who commits a conscious, premeditated murder cannot receive the death penalty in the absence of an additional aggravating factor. Yet felony murder is automatically punishable by capital punishment due to the existence of a built-in aggravating factor, a factor that creates eligibility for the penalty of death for the least aggravated form of first-degree murder. It does the opposite of what the Constitution requires of an aggravating circumstance. An accidental killing during the commission, attempted commission, or escape after committing an enumerated felony converts a non-criminal act into a first-degree murder and automatically authorizes imposition of capital punishment. Florida's felony murder aggravator impermissibly favors, for sentencing purposes, a more culpable defendant convicted of intentional premeditated murder over a defendant convicted of unpremeditated felony murder. Hence, it provides for a, quote, more severe sentence compared to others on a patently irrational basis. And they cite Blanco versus State. The circumstance thus does not serve the constitutionally mandated channeling function, nor does it justify imposition of a more severe sentence on the defendant compared to others found guilty of murder, as required by the Eighth Amendment, Zant versus Stevens. The felony murder aggravating factor, when applied to unpremeditated murder, turns a mitigating circumstance into an aggravating factor, which is not rational and is otherwise a violation of the Eighth Amendment. Lack of premeditation is a mitigating circumstance. Lockett versus Ohio is what they state. Death sentence is set aside where the state death penalty statute did not provide for full consideration of the mitigating consideration of lack of intent to cause death. Because this automatic factor in a felony murder prevents the meaningful consideration of lack of intent to kill as a mitigating consideration, the felony murder circumstances violates Hitchcock versus Duggar, 481 U.S. 983, 1987. Florida death penalty statute improperly limited full consideration of mitigating circumstances despite being initially approved in Proffer versus Florida. The Florida felony murder circumstance is therefore unconstitutional. In the context of a homicide committed during the commission of an enumerated felony, there is no general litigating of the class of persons eligible for the death penalty to the, quote, most aggravated and least mitigated, unquote, of first-degree murders. They cite Phillip versus State. Instead of genuinely narrowing the class of person eligible for the death penalty, the felony murder aggravating factor automatically expands the class of those eligible for the death penalty for no rational reason, since an accidental homicide committed during a robbery is not as culpable as is a premeditated homicide. To serve the proper narrowing function, a constitutional death penalty scheme, quote, cannot use factors which, as a practical matter, fail to guide the sentencer's discretion. Stringer versus Black is what they cite. By making a defendant convicted of felony murder automatically eligible for the death penalty based upon the same felony that was used to establish the defendant's conviction for murder, this scheme simply does not narrow the class of convicted persons who become eligible for the death penalty. Rather, if anything, it clearly enlarges the eligible class in an irrational, arbitrary, and capricious manner in violation of the guarantees of due process and freedom from cruel and unusual punishment. Many years ago, Justice Anstead expressed this very concern about this aggravating factor. Quote, this aggravator, as contained in Section 921.1416D Florida Statutes 1995, may well be unconstitutional when applied to a defendant convicted of felony murder, when the same felony used to establish guilt of first-degree felony murder is again used as an aggravator to justify the imposition of the death penalty. Florida's felony murder aggravator may well fail to meet the U.S. Supreme Court's mandate that aggravating circumstances in the state's death penalty scheme must, quote, genuinely narrow the class of persons eligible for the death penalty, unquote, and, quote, reasonably justify the imposition of more severe sentence compared to others found guilty of murder, unquote. And they cite Zant versus Stevens. Evolving standards of decency render the felony murder aggravator unconstitutional. The Eighth Amendment prohibition against cruel and unusual punishment includes punishments which are disproportionate for the offender or the crime as determined by evolving standards of decency. Evolving standards of decency mark the progress of maturing society and is a standard for evaluating governmental procedures under the Eighth Amendment. They cite Trope versus Doles. Guaranteed a proportional punishment is a, quote, precept of justice, unquote, and they cite Weems versus United States from 1910. The Supreme Court has held that proportionality review under evolving standards of decency should be informed by objective factors and, quote, the clearest and most reliable objective evidence of contemporary values is the legislation enacted by the country's legislators. Penny versus Lang is what they cite. Of the 27 states that authorize the penalty of death for capital murder, only 10 authorize it for a defendant who unintentionally, accidentally, or negligently causes the death of another person. The national consensus is against the death penalty for felony murder. Compare those numbers to the following context, in which the Supreme Court has found national census against state punishments. Atkins versus Virginia. 20 of the 38 death penalty states authorized the death penalty for the mentally disabled. They cite Roper versus Simmons. 20 states had the death penalty for juveniles. Kennedy versus Louisiana. 6 jurisdictions authorized the death penalty for child rapists. They cite Edmond versus Florida. And 8 jurisdictions authorized imprisonment of the death penalty solely for participation in a robbery during which an accomplice committed murder. In Graham versus Florida, states permitted life without parole for juvenile non-homicide offenders, but the practice of actually sentencing juveniles to life only occurred in 11 states. Capital punishment must be reserved for those offenders who commit, quote, a narrow category of the most serious crimes, unquote, and whose extreme culpability makes them, quote, the most deserving of execution, unquote. They cite Roper. Citations omitted. An offender who is eligible for the death penalty as a result of committing a felony with no proof of premeditation cannot fit this criteria. Section 921.1416D, Florida statute, and the standard instruction do not meet the constitutional requirements of narrowing the class of persons eligible for the death penalty and, in fact, has the opposite effect. The Florida felony murder circumstance is unconstitutional as explained above. Wherefore, Stephen Michael Stearns requests this court to declare Section 921.1416D Florida statute from 2017 unconstitutional under Article 1, Section 9 and 17 of the Florida Constitution and the 5th, 8th, and 14th Amendment to the United States Constitution. And it's signed Miss Melissa Vickers, who is the public defender. This is the second document. It's titled Motion to Declare Sections 921.141 and or 921.1416B Florida Statutes and or the Standard 6B Instruction unconstitutional, facially and as applied. It states, the defendant, Stephen Michael Stearns, moves this court to enter its order declaring Section 921.141 and Section 921.1416B Florida Statutes and the corresponding 6B Standard Instruction unconstitutional and precluding their application at bar for the following reasons. 1. The defendant is charged with capital homicide in which the state is seeking the death penalty. 2. Among the statutory aggravating factors which the jury may consider at penalty phase, if supported by the evidence and proven beyond a reasonable doubt, are whether A, the capital felony was committed by a person previously convicted of a felony and under sentence of imprisonment or placed on community control or on felony probation, footnote omitted. B, and there's emphasis added to this one, the defendant was previously convicted of another capital felony or of felony involving the use or threat of violence to the person, emphasis added. C, the defendant knowingly created a greater risk of death to many persons. B, the capital felony was committed while the defendant was engaged or was an accomplice in the commission of or attempting to commit any robbery, sexual battery, aggravated child abuse, abuse of an elderly person or disabled adult, resulting in great bodily harm, permanent disability or permanent disfigurement, arson, burglary, kidnapping, aircraft piracy, or unlawful throwing, placing, or discharging of a destructive device or bomb. E, the capital felony was committed for the purpose of avoiding or preventing lawful arrest or effect an escape from custody. F, the capital felony was committed for pecuniary gain. G, the capital felony was committed to disrupt or hinder lawful exercise of governmental function or the enforcement of laws. H, the capital felony was especially heinous, atrocious, or cruel. I, the capital felony was a homicide and was committed in cold, calculated, and premeditated manner without any pretense or moral or legal justification. J, the victim of the capital felony was a law enforcement officer engaged in the performance of his or her official duties. K, the victim of the capital felony was an elected, appointed, or public official engaged in the performance of his or her official duties if the motive for the capital felony was related in whole or part to the victim's official capacity. L, victim of the capital felony was a person less than 12 years of age. M, the victim of the capital felony was particularly vulnerable due to advanced age or disability or because the defendant stood in a position of familial or custodial authority over the victim. N, the capital felony was committed by a criminal street gang member as defined in statute 874.03. O, the capital felony was committed by a person designated as a sexual predator pursuant to statute 775.21 or a person previously designated as a sexual predator who had the sexual predator designation removed. P, the capital felony was committed by a person subject to an injunction issued pursuant to statute 741.30 or statute 784.046 or a foreign protection order accorded full faith and credit pursuant to statute 741.315 and was committed against the petitioner who obtained the injunction or protection order or any spouse, child, sibling, or parent of the petitioner. 3, the state will attempt to raise the, quote, prior violent felony, quote, aggravator as an aggravating factor during a penalty phase proceeding. 4, the prior violent felony aggravating factor of section 921.1416B and its corresponding standard instruction is unconstitutionally vague and overboard and has been applied in an overboard fashion and in an arbitrary and inconsistent manner. 5, because this unconstitutional circumstance has been and continues to be used as a basis for imposing a number of death sentences in this state, because its unlawful use makes proportionality review arbitrary, and because its bare terms are all that is required to be read to sentencing juries. Section 921.141 Florida statutes as a whole is unconstitutional. See Herring versus State. 6, Section 921.1416B, its standard instruction and the death penalty as applied in Florida thus violate the 5th, 6th, 8th, and 14th Amendments to the United States Constitution and Article 1, Sections 9, 16, 17, 21, and 22 of the Florida Constitution. Memorandum of Law. This is a capital case in which the prosecution is asking this court to impose the death penalty. Accordingly, heightened standards of due process apply. See Elridge versus State, heightened standard of review, Mill versus Maryland. In reviewing death sentences, the court has demanded even greater certainty that the jury's conclusions rested on proper grounds. Proffer versus Wainwright. Reliability in the fact-finding aspect of the sentencing has been a cornerstone of the Supreme Court's death penalty decisions. And They cite Beck versus Alabama. Same principles apply to guilt determination. Where a defendant's life is at stake, the court has been particularly sensitive to ensure that every safeguard is observed. They cite Gregg versus Georgia, plurality opinion citing cases. A death penalty statute is unconstitutional if it has, quote, standards so vague that they would fail adequately to channel the sentencing decision patterns of juries within the result that a pattern of arbitrary and construed, it shall be construed most favorably to the accused. The principle of strict construction is not merely a maximum of statutory interpretation. It is rooted in fundamental principles of due process. They cite Dunn versus United States. Rule is rooted in fundamental principles of due process, which mandate that no individual be forced to speculate at peril of indictment whether his conduct is prohibited. It cites thus to ensure that a legislator speaks with special clarity when marking the boundaries of criminal conduct. Courts must decline to impose punishment for actions that are, quote, plainly and unmistakably, unquote, prescribed. This principle of strict construction of penal laws applies not only to interpretations of the substantive ambient of criminal prohibitions, but also to the penalties they impose. They cite Bill Foucault versus United States. It applies to Florida capital proceedings. They cite Trotter versus State. Sentence of imprisonment, aggravating circumstance. Great care is needed in constructing aggravating circumstances. In Maynard versus Cartwright, the court wrote, the difficulty with the state's argument is that it presents a due process clause approach to vagueness and fails to recognize the rationale of our cases constructing and applying the Eighth Amendment. Objection to vagueness under due process clause rests on the lack of notice and hence may be overcome in any specific where reasonable persons would know that their conduct is at risk. Vagueness challenges the statute's non-threatening First Amendment interests are examined in light of the facts of the case at hand. The statute is judged on as-applied basis, cites claims of vagueness directed at aggravating circumstances defined in capital punishment statutes are analyzed under the Eighth Amendment and characteristically assert that the challenged provision fails adequately to inform juries what they must find to impose the death penalty and as a result leaves them and appellate courts with the kind of open-ended discretion which was held invalid in Furman versus Georgia. The court held in Maynard that jury instructions which violate these principles are unconstitutional. Substantive due process and equal protection principles require a provision by law, including criminal statutes, be rationally related to its purpose. They cite Reed versus Reed, Potts versus State, State versus Potts. The prior violent felony circumstance, as it has been interpreted, does not satisfy any of these constitutional concerns. The first problem with the Florida Supreme Court's application of the circumstances is that it does not require the prior conviction to be used as a basis for imposing a death sentence to be final. Even a conviction pending on appeal may be used as a circumstance. See Ruffin versus State from 1981, Peake versus State from 1981. Such an interpretation violates the due process and equal protection rights to an appeal and the Eighth Amendment, narrowing requirements and proscription that the death sentences, quote, cannot be predicted on mere caprice or on factors that are constitutionally impermissible or totally irrelevant to the sentencing process, or on materially inaccurate information. They cite Johnson versus Mississippi, 1981, 1986, 1989, and 1988, reversing affirmance of death sentence where sentence based on prior violent felony, which was later vacated. The second problem is the expansion of the circumstance to permit contemporaneous violent felony convictions to be treated as a, quote, prior violent felony. Florida permits any conviction prior to sentencing to be treated as a prior violent felony, even if that conviction arises from the same criminal episode as the capital felony, and even if the capital and other charges are tied together. They cite Lucas versus State. While the court has limited the contemporaneous conviction circumstances to preclude its use where there is a single victim, and they cite Wasco versus State from 1987, that limitation does not save the circumstance. The court's interpretation is not related to the purpose of the circumstance to punish more severely those who have committed violent crimes in the past. The individualized assessment of the appropriateness of the death penalty is a moral inquiry into whether a person convicted of first-degree murder has a history of violence, and exposes those who have no history of conviction for a violent felony to a greater likelihood of receiving death. The broad application of the circumstance thus fails to, quote, genuinely narrow the class of death eligible is, quote, wholly unrelated to the blameworthiness of the particular defendant, and relies on conduct that is, quote, irrelevant to the sentencing process, unquote. And they cite Zant versus Stevens, 1983. The standard instruction is unconstitutionally vague and similarly misleads jurors into considering unlawful and constitutionally irrelevant factors in deciding whether death is the appropriate sentence. Wherefore, the defendant moves this court to enter its order, 1, declaring Section 921.141 and Section 921.1416B Florida statutes and the 6B jury instruction unconstitutional, or 2, preclude the state of Florida from arguing the 921.1416B instruction. And that's all for document 2. Now I'm going to go ahead and read document 3, and then the next video will be out tomorrow at some point. Let me go ahead and make it clear that all of these documents are the state of Florida as the plaintiff versus Stephen Michael Stearns as the defendant. This one made me the most upset today out of all of them. This is a motion in limine to require state to proffer any and all victim impact evidence. Comes now the defendant Stephen Stearns by and through the undersigned attorney pursuant to sections 90.104 and 90.105 and 90.403 Florida statutes and Rule 3.190 Florida Rules of Criminal Procedure, and moves in limine to require the state to proffer out of the presence of the jury any and all victim impact evidence, and as grounds therefore would show as follows. 1. Victim impact evidence, particularly in a death penalty trial, is normally of an extremely emotional nature and has a high probability of unduly, unfairly, and unconstitutionally inflaming the jury, thereby making it impossible for the defendant to get a fair sentencing phase of his trial, free of bias and prejudice. Well. 2. The definition of victim impact evidence in section 921.1418 is vague, ambiguous, and difficult to interpret. In addition, victim impact is not considered an aggravating factor. 3. Victim impact witnesses, particularly in a death penalty trial, can be extremely emotional and have a great difficulty controlling their emotions while testifying. 4. The defendant, by the filing of this motion, maintains any and all objections to the use of victim impact evidence in its entirety. Wherefore, if the court allows victim impact evidence, the defendant respectfully requests that the court enter an order requiring the state to proffer out of the presence of the jury any and all victim impact evidence, so the court can determine not only whether the evidence is appropriate under the statute authorizing it, but that the witnesses themselves are emotionally capable of maintaining appropriate decorum before the jury so as to avoid unfairly and unconstitutionally inflaming the jury and causing prejudice to the defendant. And the rest of the pages are just where it's signed. If you would like to see a lovely breakdown by my lovely Mod Hio and myself on live today, it is in the video, in the live stream that we put out today. It has a picture of Maddie with like a mermaid tail, like the fish scale background. It says, new docs we need to discuss ASAP. Just by the way, so that you know, because people have already been asking me about this, in that video, I had to remove a video that is really sad of Maddie. It's going to make you cry. The video is linked in the description box. It is the first link if you want to watch that. I had to remove it due to copyright issues. Thank you so much for watching this video. Be on the lookout for the next video. It will have a motion to declare 921.1416M unconstitutional facially and as applied mictum vulnerable due to age, disability, or familial or custodial authority. That's a 17-page document. Motion in limine regarding penalty closing arguments, and motion in limine regarding penalty. Oh, I think that's the same two. So it'll have those two in it. One of them 17 pages, one of them 6 page. And if I'm missing a document, I will find it and have it for you then. Thank you so much for watching this video. Please remember to like and subscribe. I appreciate your time. Thank you for watching this video all the way to the end. You are so amazing. Have the best night ever. Bye.